Hello, my name is Dan Dodds. I'm the principal attorney at the Dodds Law Firm in Surprise, Arizona. Today I wanted to talk about the 3 reasons why most people will settle their case before they ever go to trial. And there are 3 really solid reasons. But I want to ask you a question first. Of all the hundreds of thousands of cases that are filed in the United States, at the state level, at the federal level, at the city level, I mean, there's just hundreds of the thousands of cases. Here's a statistic that ought to cause you to blink. What percentage of those hundreds of the thousands of cases ever go to trial? And the most recent statistics I've seen is this. Only 5% will ever see the inside of a courtroom. Whoa. Why? Well, now I'm going to give you the 3 reasons why. The first reason is often people just run out of money. They can't continue to fight because fighting is expensive, takes up a lot of it. Attorney time, motion work, court hearings, depositions, production and response to discovery, which all cost money. So they ultimately just run out of money and go, hey, I got to settle this. I can't go the distance. The second reason, and I think it's increasingly more a problem, is quite frankly, they're just exhausted all their emotional energy to keep fighting. They just don't have anything more in their soul that they can drag out. It's so hurtful that they just want to settle it because it's eating them. The third reason is the 95%. They become fearful of assuming too much risk by going to trial because they know no matter how talented their attorney is, know how hard they've put it together, no matter how strong the case law is, they could lose. And the risk of losing is too high. They don't want to have to pay the cost to go to lose, and then gee whiz, if it's a civil matter, you may wind up having to pay the attorney's fees to the other side that just won. So they become very fearful. So I'm just giving you the blunt reality. Yes, I think my clients over the years have been very pleased. We've won a number of cases. I think most attorneys would be somewhat jealous of the win-loss record we have. But we've lost some cases too. And every good attorney will admit that. So the reality is 95% of the time, people are going to settle their differences before they have to walk into that courtroom because they don't want to spend every dime they've got to win and then come up with what? I'm just in debt. They get worn out emotionally, they don't sleep, they're nervous, they cry, they just don't have any emotional energy left. And they just don't want to take the risk that they might lose instead of walking out of that courtroom going, wow, we did it. And then the other person files bankruptcy and wipes out the judgment. So I hope these reasons that you will take them in the spirit that I'm giving them to you is, yes, you should never retain an attorney that's afraid to go to court and do their best to win a case for you. But it shouldn't allow it to bankrupt you either. So if you can bring a mindset to the discussion of, well, what would it take for your attorney to negotiate a settlement with the other side that you could live with, but it would be certain and it would be quicker than having to spend a lot of money to go to a trial. At best, maybe your odds are 50-50. Okay, well, I hope that information is helpful. If you would like to talk to me about your particular case, I'd be more than glad to spend some time with you and try and help you out. Have a good day.